Thank you so much. Namaskar, everyone. Good afternoon. So, I am CS Suresh Pandey on behalf of Institute of Company Secretaries of India. I warmly welcome all our esteemed member and respected faculty to the third session of Triple E 5.0 Master Knowledge Series and focusing on a subject of immense relevance, that is intellectual property rights and trademark concept to protection. So in today's session, in knowledge-driven economy, protecting intellectual asset, especially trademark, is not just a legal necessity, but a strategic imperative also. So trademark are key to brand identity, consumer trust, and market competitiveness. And as a governance professional, as a company secretary, play a pivotal role to ensuring proper registration, compliance, and enforcement of strategic management of these valuable assets. And these assets are very, very, very important for the company. So, as the same time, as proud citizen of this great nation, we stand in strong solidarity with our armed forces, and through our work in corporate governance and law, we reaffirm our commitment to the nation's progress and security also, and legal integrity also. So as a company secretary, we all should give this message to our government. So to guide us through the technicalities of this subject, we are privileged to have with us CS Nayan Rawalji, a seasoned professional with over 25 years experience in corporate law and intellectual property right. He is a company secretary, advocate, and India's first IP coach, you can say, with rich experience in IPR, M&A, FEMA, and IP basically area. We are honored to welcome you, sir, and on behalf of ICSI and on behalf of all the participants, I would like to express my gratitude of thanks. And sir, you are always available for the institute. And on behalf of all the participants, on behalf of ICSI, I welcome you, sir. Now the floor is open, and I request with all the participants that you can post your questions also in the question box. And after completion of the initial deliberation of Nayan sir, I will take some important question, although it could not be possible for us to take all the questions, but you can mail your question, and it should not be very personal, but I will try to cover each and every question with the paucity of time. So thank you, sir.
Yeah, thank you so much, Pandiji. And first of all, I should thank you for wonderfully and so nicely introducing me. And thank you so much. The most important thing in your introduction was that IPR is not only legal, it is strategic decision. And there are some things which are very important in IPR, which I'm going to tell. To that fact, let me tell you very frankly, today what I'm going to deliberate in this lecture is not more on the legal aspects of the IPR, but the fundamental aspects. What is the fundamentals of IPR? What exactly is IPR all about in this world? And what could be the real role of a company secretary in today's absolutely disruptive environment where there are so many compliances, and why additionally company secretary will bother to learn about IPR, or why you should take care of IPR, and what is that something which will really impact the company secretary's profession as far as IPR is concerned. Let me make it a little bit interactive. I know that the participants are not allowed to speak, but at least they can communicate through chat, correct?
Is that? Yes, sir. Yes, sir. They can post their answer through chat box.
So I may ask some, let's have a deliberation. There are only always three things which I try to answer whenever I try to do something which is the task before me. Why should we learn intellectual property? That's the first question. What should we learn in intellectual property, and how should we learn something about the intellectual property? So this why, what, and how. This is what Simon Sinek says, that we should always answer why, what, and how of anything. Then direction becomes very clear, correct? So why should we learn intellectual property? Let's ask some of the participants that why should we learn intellectual property? You can type here and let me have your feedback, and that will make my journey more fruitful and purposeful as far as next 2 hours is concerned. So why should we learn intellectual property? Can anybody tell me?
Sir, we are getting some answer because they are saying it is their part of job, and
Yeah.
some members are typing because they are working in pharma company, so it can be a big
Yeah.
asset for their company.
No, no problem. No problem. Let it.
Directly,
I'll not be able to see those answers.
yeah, you like there is, I think, some problem because I am getting some answer on my WhatsApp.
But I could not see anything in chat box.
Yeah, because we are in basically
Okay.
webinar mode. So in webinar mode, the person who is
No,
controlling
no
this
issue about
company,
it. But you
yeah,
are there as a coordinator, so you.
yeah.
So there are some people from pharma company. They said that it's a kind of their job routine work. Correct. No problem. No problem. No problem. Yeah. Then there are some people from pharma company. I have been deliberating this subject with last 25 years. I have been even speaker at the ICAI and engineering colleges and everywhere. I go and shake hand with somebody who is not from pharma company. Because that's the biggest myth that IPR is only for pharma company. The highest patent holder in this world is Intel. It is not a pharma company. It is not a pharma company. Correct? So the question again still remains, why should we learn IPR? It's only a job. It's only an kind of an additional compliances. Yeah. Is there any new answers to this?
I am also trying to find it out, sir. I'll let you know.
Yeah.
I think you can go ahead because
Yeah, sure.
yeah.
Okay. Now
I
let me
think
change. Let me change this deliberation in a different direction. Who's the richest person in this world? Who's the richest person? Or name few very multimillionaire people of this world. Who are multimillionaire or rich people in terms of their wealth, their organizations, their value. Who are the some few people, rich people in this world?
Sir, I think in the question answer mode, we may face some kind of problem because here we are using some agency which is basically
No issue about it. No issue.
broadcasting this webinar to all the members. So although this is a live session, but two-way communication may create some problems, sir.
Yeah. No, but they
I'm
will,
sorry, sir.
in chat box they cannot type.
They will type, but it immediately we cannot see this.
Okay, fine. So should we wait or should I?
No, sir, I think we should change our mode of deliberation. So, despite of asking question, like you can question it and give some time and you can answer it also.
Yeah, no problem, no problem. So did you get any?
Either I can help you if you want.
Definitely.
Yeah.
Not an issue. जो technical available है उसी का इस्तेमाल करके हम will
Correct, sir.
utilize this 2 hours. Not an issue about it.
So, Elon Musk, or
Yes,
you
Elon
can say
Musk
Mukesh
or
Ambani in
Jeff
India,
Bezos.
or Mr. Adani in India. So,
Yeah. So why they are rich? Why is Elon Musk rich? Just because he's having big company? Because he had innovations.
yeah.
Yeah.
Correct.
Microsoft is Bill Gates is rich because he brought first time something called Microsoft.
Yes.
So they have innovations. Correct?
Correct, sir.
Just a few days back in newspaper, there was an headlines. If the company securities are updated with what is going on in the world, corporate world specifically, and the economies.
Yeah.
India has been put into the priority list of Super 301. Super 301 is a particular provision of, say, trade of US trade representative department have a particular act called Omnibus Guarantee Act, Omnibus Trade Guarantee Act, where the bilateral relationship, this is the hot topic since last 3 months or since January when the new president of US has come. Correct? And they have put India also on the priority list.
Yes, sir.
Saying that India is not that much of IP compliant. Yeah. So
Yes.
we are the compliance people. I think if we get involved more and more into the IP, we'll be able to eradicate this black spot on that priority list of the US. Correct? So these are some reasons for which I feel you should learn IPR, and that is the why. So let's see what is what and how. And now I can share my presentation. Share
Yes,
screen.
you can share, sir.
Yeah. Uh, sir.
At the
Sorry.
bottom, there is one button you need to.
Yeah. I have to open my presentation.
Yes, sir.
Open my presentation and then share it. Correct? Yeah.
It is visible now, sir.
Yeah. So this is what I am going to do today. Is by end of this session, you will see the concept, identify the concept of intellectual property, purpose, explain the purpose of intellectual property, economic aspects of the intellectual property, association, associate your need of intellectual property in the cyber world, interpret the national and international perspective on the need of intellectual property and the types of intellectual property. These are some answers which I will be able to deliberate at the end of this session. So, yeah, before this, I want to have this beautiful sentence: imagination is more important than knowledge. Yeah, this man has really helped me to understand IPR, and he's still motivating me to understand and study IPR. I am still a student of IPR. Though I have a more than 23 years experience, I'm still feel that I'm learning new and new things in IPR. Like we have AI now. So AI, what are the issues of IPR? Yeah, AI is creating something. So machine will own that matter, or the person who has created through that machine will own that matter. This was one
That
question.
person who is creating the
Yeah.
machine.
Now the machine does what? The machine does what is given to him. So who is giving that? So these are some questions which still I am trying to find out through. So that's what is the
Correct.
point of IPR. Imagination is more important than knowledge. Everybody has knowledge. Yeah. Everybody around the world has knowledge. But who imagine that how can we put this knowledge into more productive use? And those people who make this imagination work on the basis of knowledge they have or the world has create something called intangible products. And that's the trigger point of IPR. That's what is the what of the IPR. Yeah, that's what is the what. Imagination is more important than knowledge. Yeah. So, what is intellectual property? Intellectual property is a legal right resulting from intellectual activity in the industrial, scientific, artistic, and literary field. It's a right associated with innovation and creativity, more mental as against physical products, example, land and other intangible process. Let me tell you very frankly, the study of immovable property and the intangible property has the same system. What is applicable to immovable property is also applicable to intangible property in terms of the system, in terms of interpretation, in terms of law, in terms of transfer, in terms of acquisition, instead of selling, buying, whatever it is. It's almost same system. Actually, it differs only with one feature, that immovable property can be physically possessed. Immovable property can be physically possessed. Intangible property cannot be physically possessed. You have trademark, but you cannot say ये मेरा brand है. हाँ, brand दिखाने के लिए है, physical उसका existence कुछ नहीं होता है. It is applied to some, it is manifested in some form or other. Like if you have brand, it is manifested in the form of a trademark. If you have some imagination in terms of your writing, music, ideas, whatever it is manifested in some form. See, that's how the possession happens. Otherwise, you cannot physically possess any of the intangible assets. That's the major difference between the immovable property and the intangible property. Yeah. So intellectual property deals with all these subordinates and intermediates. ideas, inventions, technology, artwork, music, literature. Let me tell you, each and every person around the world have intellectual property. Something is intellectual property. Your life in the morning starts with intellectual property. सबसे पहले जब सुबह हम उठते हैं तो मुंह धो के ब्रश करने जाते हैं. The brush and toothpaste which you are using are branded. So that's where the intellectual property starts with. Yeah, you go and take bath, you use the soap, that is branded. You wear clothes for going office, that is again branded. So you are using intellectual property in every respect and every manner. Every day you come across the intellectual property, it's the realization. Yeah, even a housewife is having an intellectual property. Any housewife can even have an intellectual property. Have you heard about somebody called Tarla Dalal? Yeah, she was a lady who was a cook. She had an absolutely flair for cooking. Today she is no more there, but she is having her family inherited that property. Their family has inherited that property in form of so many books. They are all copyrighted books. That's the literally content which she left as a legacy for the family. She was just a plain housewife. So even a housewife can create intellectual property and absolutely utilize or explore it in her personal life as well as the professional life. So intellectual property deals with ideas, inventions, technology, artwork, music, literature, anything and many more. These are some few examples which I have given. Yeah. IP is intangible when created, but becomes valuable form as a product. Yeah, it's a very simple thing, sir. ये छोटा सा पेन है एक, yeah, but इसके अंदर कितना टेक्नोलॉजी, कितनी आइडियाज, कितना इन्वेंशन, कितना म्यूजिक, सब कुछ आ सकता है इसके अंदर. Yeah, we can have everything. It's a simple writing device. But किसी ने सोचा होगा, in traditional days there was no medium to write. We used to write with the feather of a bird. Now we are writing, and कितने brands है इसके, कितने quality की pens है. In US they have a kind of an innovation where when you write, it smells, it spreads the fragrance. अरोमा, लिखते वक्त अरोमा फैलता है, इंक में से अरोमा फैलता है. Yeah, now that's the experience. That's the experience of intellectual property in so many other different ways. Yeah. So what is exactly intellectual property? This is the formal definition of intellectual property. I have not devised this definition. This is devised by a body called WIPO. WIPO is World Intellectual Property Organization. It's a 100-year-old intergovernmental agency which administers protection, fundamental principles, and system of IPR worldwide. Worldwide, WIPO is the father of absolutely all the administration, new kinds of problems, solutions for different types of IPR. They have defined intellectual property, and the formal definition of intellectual property is industrial property, copyright, and related rights. Yeah. So what does industrial property talks about? It says that if you have innovation and invention, you can qualify to get a patent as an intellectual property. If you have anything which has got configuration, pattern, dimensions, design, that can be registered as design. Yeah. If you have a brand, it can be protected as trademark. There are certain kinds of products which are originated only in certain regions. That is called appellations of origins. They have characteristics, features attached to a particular region. Beyond that region, those characteristics and features of that product will not be available. They are entitled for geographical indication. The best example is the Darjeeling tea. Can you cultivate Darjeeling tea in Noida? Can you cultivate Darjeeling tea in Jaipur? Can you cultivate Darjeeling tea in, say, Mumbai? Can you cultivate Darjeeling tea in South? No, it can be only cultivated in Darjeeling, because that's the feature and characteristics of the product which is available there only. I can give you a few more examples like Banarsi silk. बनारसी सिल्क सिर्फ बनारस से आएगा, कहीं और से नहीं आ सकता है. There are so many things like that. अल्फोंसो मैंगो, हाँ, कैरी की सीजन चल रही है आजकल, मैंगो की सीजन चल रही है. It is said that anything grown between Goa to Palghar, जो भी मैंगोस कल्टीवेट किए जाते हैं गोवा टू पालघर, दे कैन यूज अ टैग ऑफ ज्योग्राफिकल इंडिकेशन दैट दिस इज द अल्फोंसो मैंगो. Correct? So there are regions, and those regions have certain appellations and features which are attached to that particular region. Yeah. Trade secrets. The biggest trade secret, the corporate trade secret, is the Coca-Cola formula. Yeah, it's the Coca-Cola formula. The biggest corporate trade secret is the Coca-Cola formula. Only 7 board of directors and members knows what is that formula originally. The rest, nobody knows that. This is the biggest trade secret for more than 100 years in this world. The next is integrated circuit or chips. Says semiconductor chips. This is called semiconductor chips. This chips helps to create convergence of technology. Convergence of technology means, say, you can watch a movie even on computer. कंप्यूटर पे हम सिर्फ काम करते हैं, लेकिन हम उसमें मूवी भी देख सकते हैं, पिक्चर भी देख सकते हैं. Your mobile, the highest convergence of technology happens on mobile. Mobile does the job of a camera, it does a job of a messenger, it does a job of an kind of an creating, say, social medias, everything. So that one single tool is useful for so many things. It does even a job of a computer. Yeah, you can open a Word file, a PDF file, even on your mobile. So how that is possible? That's because the convergence of technology happens. And that convergence of technology happens because there is a medium which is called semiconductor chips. Those chips are doing so many other functions. Like if you see today the car, absolutely there is a car which can run without a driver. US may the car run without a driver. Absolutely it is possible. उसको किस तरह से वो सॉफ्टवेयर बना होगा, किस तरह से वो टेक्नोलॉजी बनी होगी, वो सिस्टम, that's all because there are various kind of semiconductor chips which helps into convergence of technology. On the other hand, we have copyrights and related rights. It is said that copyrights and related rights or copyright exist in different kind of work, and that work could be literary work, it could be dramatic work, it could be artistic work, it could be musical work, it could be cinematographic film, rights related to performers and broadcasters and sound recorders. So literary work is something which is absolutely a content. Today, data and content has become an oil, most important raw material for so many industries. So many players. Like without data, you are absolutely nothing doing. You're not nothing. You're nothing in this world. So literary work could be in the form of something books, data, content. Dramatic work, it could be any creativity, like dramas are there. It could be anything. Artistic work, yes, sculptures. Let me tell you one thing, that IPR is something which we have given to the whole world. IPR is something which we have given to the whole world. It is nurtured by them and that come back to us. Now, this is what normally happens in every aspect of our country. Yeah. The first trademark on this earth or on this universe was created by Indians. The first trademark on this earth and on this universe is created by Indians. How? In olden days, we were very prominent. We were very efficient in creating antique pieces, sculptures. Yeah, that's where the artistic work comes. Those artistic works were actually sent to the whole world, various kingdoms, various emperors, and specifically in Middle East, the Middle East emperors and kingdoms were very fond of the Indian sculptures. So we used to send all the sculptures from here to them, and in exchange, there was no money exchange. There was no money exchange in those days. It was the barter exchange which used to work. हमको बहुत सारे सोने, जवाहरात, precious stones, सब कुछ मिलता था. That is how the country has become so rich. Yeah, we are rich in terms of our culture. We are rich in terms of our education. So that is why we were able to benefit this 3,000 years ago. So some people to take undue advantage of our thing, they started shipping in the name that ye India se aaya hai. But those kingdoms and emperors, they found something fishy. So they communicated to Indian sculptures that kahin to bhi kuch galat hai. I don't know how do we come to know that this sculpture or this antique pieces come from India. So the Indian sculptures were very intelligent. They know how to handle things. So they said that whenever next time we'll sell any kind of statues or antique pieces, we will engrave our signature. We will engrave our signature on that, and below that signature हम हिंदू डेट लिखेंगे. हिंदू डेट सिर्फ इंडियंस को लिखने आती है, किसी और को लिखने नहीं आती थी उस जमाने में भी और आज भी. Nobody knows how to write an Hindu date. It's only the Indians who knows to. So this together, the signature and the date together became the first trademark in this world. And I'll tell you, this information I have not got from India. This information I got from WIPO. When I was doing a research on a trademark, I got this information from WIPO that this is the first trademark born on this world. So that's all. Artistic work. They are having absolutely photographs, music. Yeah, हम होटल में जाके म्यूजिक सुनते हैं ना, वो म्यूजिक का पैसा हम भरते हैं, होटल वाला नहीं भरता है. Nothing is free in this world. There are so many companies who receives, or so many institutions which receive and notice from T series that आप हमारा गाना फ्री में बजाते हैं, आपको पैसा भरना पड़ेगा. अगर आप पैसा नहीं भरेंगे तो we will file a suit for copyright infringement. That's how music industry is working. T series is created only on copyright as a business model. Copyright is the big backbone of the business model of T series. That's how that organization is built upon one IPR. Yeah, this is the most neglected IPR. Yeah, cinematographic films. Yeah, films बनती है. It is said that the Indian Bollywood is losing every year more than $4 billion because of piracy. Now piracy is a different way. पहले वीडियो पायरेसी था, फिर सीडी पायरेसी आया, अभी डेटा पायरेसी आया. We have even data piracy today. Yeah, so it's only the medium which changes, but the core remains the same. Just imagine the kind of enforcement of copyright needed in this country. We can save more than 4 billion only for Bollywood. There are so many regional industries in terms of their cinematographic films as copyright and as an intellectual property. So this is something which is the bare pillar of what is intellectual property all about. You have industrial property and you have copyrights and related rights. Let me tell you one small commercial example of copyright and related rights. Everybody has heard about Harry Potter? Yes. Everybody has heard about Harry Potter? Yes. Everybody has heard about Harry Potter. You know, the author of Harry Potter was J.K. Rowling. Now, J.K. Rowling was a lady who was divorced by her husband. And in terms of the divorce, she didn't get so much of money to survive herself, and she had one son. So she had to survive herself and her son. That was not enough. So she started, I have to survive and I have to start finding out ways and means to have earning for myself. So she had a flair for writing from her childhood. She was very good in writing. So she started writing small articles for some periodicals and magazines in USA. So those magazines and those periodicals was looked upon by a very senior editor of New York Times. And he found it very interesting. So she said, she was invited and said that please come and we will give you a kind of some kind of a job where I feel you can do better things, and you start writing for New York Times. Slowly, gradually, her popularity increased. So say that if you're doing some good writing, why don't you create some good writing about it? So she created the first novel. She wanted to make happy her own son. So to make her, she started telling stories to her son. And she started writing stories for her son. Yeah. And that's how she created the whole big, huge property of Harry Potter. 8 series. I think we have 8 series of Harry Potter. Yeah. And Harry is nothing but her own son's name. She created it for her own son. Today, she had a big legacy of licensing rights of Harry Potter. She's hiring more than 100 IP lawyers all over the world to negotiate and take care of the licensing rights of Harry Potter. Harry Potter is translated into 18 foreign languages. Foreign languages, you say Japanese, Brazilian, Martini, whatever language it is more than 15 to 18 languages it is translated. And every translated work is an original literary work in terms of copyright law and system. Now that's the wonder that she is correct. So that's the why and how intellectual property will come in picture. Yeah. So issues in IPR. Issue is what is to be protected. The technical issue is what is to be protected. What should we protect if we have any idea or any kind of mental act which can create something new? How it is to be protected. And the economic, how to commercialize the protection. So it is create, protect, and leverage. These are the 3 ingredients which are the issues in IPR. Like I was giving the example of this. This is writing device. Correct? So when this was created first time, there was a technology involved in storing of ink. There was nobody knowing how to store ink. The concept of storing of ink came with this writing device. Correct? फिर उसको एक shape दिया गया, एक ढांचा दिया गया. तो started having design. Correct? And इसके पे अगर brand नहीं रहेगा तो कौन खरीदेगा? Will anybody buy if there is no name or brand on this? Nobody will buy. So that's all. So technical issue is what is to be protected. Should I protect the system of storing? Should I protect the design or the shape? Or should I protect the brand? Or am I supposed to protect all the 3? So these are the issues which have to be answered in IPR. And that's what we have done. This is called as a writing device. इसको pen नहीं बोलते हैं. IPR वर्ल्ड में हम इसको पेन नहीं बोलते, इसको राइटिंग डिवाइस. बोथ ब्रॉडर टर्म है राइटिंग डिवाइस. इट्स अ वेरी ब्रॉड टर्म. एंड इफ यू वांट टू हैव अ गुड IPR in any form, have to think broad, protect broad, think broad, and create also broad. And the economic issues, just imagine the value of the brands. Like अगर मुझे पार्कर ब्रांड का वैल्यूएशन करना है तो कितना आएगा? Cross an international brand, what will be the value of that? Okay, that's where the commercialization of the IPR comes. Yeah. So one product, many IPR. That's what it is. It's not just a simple compliance. It's all about strategy. It's all about commercial aspects of the IPR, which is more important. Legal is there. I don't say without legal, nothing can happen in IPR. But that legal has to also have some other dimensions. Yeah. Yeah. Now, this is something where we will go to the fundamental principles of IPR. In 1995, something happened which was very revolutionary for the whole world. In 1995, there was something very revolutionary which happened in the whole world. And that revolutionary thing was that the internet was born. And with the internet, what happened was at a click of button, information started flowing from one corner to the other corner of the world. And that became a trigger point for so many things, in the sense that information become a raw material. Information and data become an important raw material for everyone. And today also information and data is the biggest raw material. It is said that data is oil. It is that the data is oil of the new economies. Data is oil of the new centuries. Yeah. So in 1995, the whole world started thinking beyond trades and tariffs. It said that we need to look beyond trades and tariffs, and that's how WTO was incorporated. WTO came into existence because we had to think beyond trades and tariffs. And in WTO, there are 18 different aspects on which the member nation countries of WTO have signed different agreements. And one of the most important agreement is TRIPS. The objective and the purpose of TRIPS was to define the bare minimum standards which are required to be recognized in intellectual property. What are the bare minimum standards? The TRIPS has a very simple principle that we cannot interfere into the national legal system of each country. It is not possible because what US have the laws, what European have the laws, what Asians have the laws, what Singapore have the laws, what India has a law, legal system is different everywhere. So it will create complications if we try to interfere into the legal system of each and every country. So they said that let's lay down the bare minimum standards. What are the types of intellectual property? What intellectual property are to be recognized and how they are to be protected? That's how the bare minimum standards of intellectual properties were laid down in this document. As company secretaries and as company have memorandum of association and articles of association. This is the memorandum of association and articles of associations of intellectual property. One who wants to understand intellectual property fundamentally and principally, they should read this agreement. This is a very important agreement. It talks about everything about IPR, how we need to look upon IPR, how we need to protect it domestically as well as internationally. What are the reciprocal rights of intellectual property? What are the regional rights of intellectual property? What are the international rights of intellectual property? Everything is defined and absolutely laid down the basic bare minimum principles and standards for IPR. This is the most important document. It has more than 78 articles and 8 chapters. And it is a very small, say, not more than say 60, 70 page of a book. You read it and you understand more and more about IPR. So what TRIPS has, how the TRIPS was culminated, how the TRIPS was germinated. It's very simple. What this has been done, there were different bilateral agreements on different intellectual property. Like we studied industrial property and copyright. So for industrial property, there was a Paris Convention. For copyright, there was a Berne Convention. For trademark, there was the Madrid Convention. So there were different conventions for how to really explore and interpret the law and system of different intellectual property and in different geographical jurisdictions all over the world. So they took up everything which was useful and to lay, which was absolutely helpful for them to determine the bare minimum standards, and they were put into the one place, and that's how the TRIPS was born. So most comprehensive till date, incorporating substantive provisions of all the convention, enforcement provision, dispute settlement, yeah, प्रोडक्ट पेटेंट होना चाहिए या प्रोसेस पेटेंट होना चाहिए, इसका झगड़ा 2005 तक चला इंडिया में, इंडिया के लिए, right from 1995 till 2005, and ultimately it was decided that you will have to have product patent and process patent. But it's what a myth. We always had product patent in this world. The first patent law was passed in 1911 that had a product patent. It was not only process patent. So we were always having a product patent in our system, but it was created. So there is a dispute settlement mechanism also. Domain name, cyber squatting of domain name is the most serious thing which the company secretaries have to face. So that domain name settlement system is also there with WIPO. That's also out of TRIPS which has come out of it. So TRIPS is a very useful document. Anyone who wants to learn IPR in depth should actually go through TRIPS once. Yeah, that's what I had made a point that there are various conventions. So हर एक convention से छह boxes है, उससे हर एक convention से important चीजें ले गई and it was incorporated at one place. Yeah. Let's understand each and every part of industrial property first, and then I'll come to the copyright part. What is trademark? Trademark is a graphically represented, a mark capable of being represented graphically. A trademark is something which can graphically be represented, capable of distinguishing goods or services of one person from the others. Yeah, एक सिंपल मैंने बोला था राइटिंग डिवाइस, ये किसका है? ये सेलो का है. ये किसका है? ये पार्कर का है. ये किसका है? ये क्रॉस का है. ये मॉन्टब्लैंक है. डिफरेंट पेन के बेनिफिट्स, डिफरेंट पेन के फीचर, ब्रांड के फीचर रहते हैं. सो ब्रांड क्रिएट्स something which is capable of distinguishing one's goods from the other's goods. May include shape of the goods, the packing, and the combination of colors. It can include everything. What are the different types of trademark? It could be ticket, label, heading, brand, device. Yeah. Device, pictorial representation, brand, symbols, means, label, ticket. Yeah. In Europe, every football club or football league have a ticket which is unique ticket, that itself is a trademark. Yeah. In India, Colgate actually fought with each and every other toothpaste company for not allowing them to use the red and white. Red and white color packing में किसी को allow नहीं किया Colgate ने. They fought whoever one is to come out with red and white color for toothpaste packing is to fight. And he didn't allow anybody to use. He said, this is my packing material. This is also registered as trademark. I have even protected the color combination of it. I have protected the packing material also. Everything is protected. He didn't allow. For one simple reason. Colgate had a very big branding philosophy for red and white. And that red and white was nothing but हमारे दांत white color के हैं, हमारे gums red color के हैं. And that product which is sold by Colgate is toothpaste, and that was meant for the dental system. So your dental system is protected if you have Colgate in your house. That was the brand philosophy of Colgate. So one simple thing, but it had a great brand philosophy. So packing material, color combination, anything can be protected as stamp. Today we even have sound and images. Even your voice can be protected as trademark. Amitabh Bachchan voice is a trademark. Anil Kapoor's Jackass is a trademark. Jaggu Dada's Bidu is trademark. So anything could be trademark. Yeah. You have various kinds of trademarks for this. Yeah. Then we have name, word, numerals, packing, signature, letter, shape of the goods, combination of colors. These are some few examples how trademarks are created and protected. Any combination thereof. Now, these are some examples of trademark. Yeah. See, color combination. Like McDonald's has not allowed anybody to use the word MACD. Short form, even the abbreviation of the trademark is protected as trademark. वो MACD करके किसी को allow नहीं करता है use करने का. Yeah. Then we have different types of trademarks. Sorry. Nike, just do it with a right sign. Starbucks, इसमें एक princess का photo है. Starbucks as a word and then color combination of green. Together, this is called composite mark. Nike word mark. Nike itself is a word. Then the sign of right and just do it. Again, that's the punchline. You know how that just do it has come? It so happened that an international ad company was approached by Nike to create an campaign. And उनके पास सिर्फ Nike word था और कुछ भी नहीं था. उन्होंने वो right create किया. It's a right brand for the footwear. But उनको आगे punchline मिलता नहीं था. तो जो मेन बॉस था वो कैंपेन का, उसने एक जूनियर को बोला कि इतने दिन हो गए आप कुछ क्रिएट नहीं कर पा रहे हो. It is so horrible. Just do it. I don't know anything. And that just do it became the part of that trademark. किसी ने डाटा और वो trademark बन गया. See how creativity creates different kind of property in this world. Yeah. Then ISI are sometimes called certification mark. There are certain marks which are called certification mark, which has certain qualities and features to be protected. Yeah. Next is a patent law? What is exactly a patent? Patent is a grant by state to an inventor. It's a legal grant by a state to the inventor and granted to the inventor for consideration or an incentive or an investment in research. It is a contract between the inventor and the state for a limited tenure. It is a contract between the state and the inventor for a limited period. Yeah. So what exactly is patent all about? It's about an invention. And an invention is for limited period given as a monopoly to somebody. And that monopoly is given for a consideration that he is disclosing his research to the whole world. He's not keeping it with himself. He's disclosing to the people that this is my research work. This can be converted into a good product or a helpful thing. For pharma, it could be medicines. For information technology, it could be any device. So many things are there. It's an invention. So invention is the subject matter, and that invention requires a little bit of research and investment. Just because somebody has done that, he's getting that right for 20 years. So a grant to an inventor for an eligible invention. All innovations are inventions, but all inventions are not patentable inventions. It is said that all innovations are inventions, but all inventions are not patentable inventions. So then what are patentable inventions, or what are eligible inventions which can be given patent? So the system says that anything which is having novelty, anything which is having utility, anything which is having inventive step is something which is patentable. And that's where the patent is granted. So there has to be novelty, there has to be utility, and there has to be an inventive step. Let's see what is novelty, what is utility, and the inventive step. So subject matter of patent, it could be to a product or a process or a both. It should be new or novel. It has to be totally new. It cannot be absolutely which is known to the public. It has to be new. Involve an inventive step. It has to have an inventive step. It should be capable of industrial application. Not fall with the restriction as mentioned in section 3 and 4. Let's take one by one. So eligible invention, it could be a new product or a new process. It could be old product but new process. It could be new process and the old product, or any combination of it. And even an economic benefit involved in this can be protected as an invention. It has to be totally new. It has to have an inventive step. Inventive step is technical advancement against that existing knowledge. Any technical advancement against the existing knowledge, it qualifies for inventive step of a patent and has to have of industrial application. So the utility which is talked about in the patent is not a general utility, it is the commercial utility. The utility has to be commercial utility, and the patent should not fall in restrictions as mentioned in section 3 or 4. Section 3 are the list of patents which cannot be patented. Like method of medical treatment, वो हम patent नहीं करते हैं यहाँ पे. We don't allow method of medical treatment to be patented. Computer software per se, सिर्फ software है तो वो protect नहीं होगा. But if there is a technology or a device involved in software, that can be protected as a system. But program per se cannot be protected. In section 4 is all related to atomic energy. So atomic energy patents are not patentable in India for the purpose of defense and security reasons of the country. So what is new? New means it should not be published in India or elsewhere, not to be in public knowledge or public use within India, and it should not be claimed in any specifications in India. Specification is a document through which we apply for patent. Specification is a legal technical document in terms of the patent law, what is required to prove your novelty, utility, and the inventive step. So what is new? It should not be published anywhere. That publication can be even on publication on internet or a site. It should not be known to anybody. It should not be in a public knowledge or public use within India. आपने अगर यूज किया है तो उसका नोवेल्टी चले जाता है. You cannot protect it. So before actually doing the commercial application of something, if you have an invention, better protect it as a patent. Next, it should not be forming a part of a specification. It's a legal techno-legal document to get the patent. Yeah. So it is said that technical advance, it involves technical knowledge as compared to existing knowledge. Like if you see IT industry, when computer came for the first time, we were having simple systems. Then we had capacity and processors, different kinds of processors. उसके लिए अलग अलग डिवाइसेस होते थे, अलग अलग कंप्यूटर्स होते हैं. उसके बाद हम सीडी पे आए. अभी आज हमारे पास ना सीडी है ना कुछ भी है. Everything is absolutely on cloud. It is called cloud. Yeah. So if you see this is the technology advance compared to the existing knowledge. मोबाइल जब पहली बार आए तो उसमें व्हाट्सएप नहीं था. उसमें कंप्यूटर या ईमेल नहीं चेक कर सकते थे. इसमें वर्ड या पीडीएफ फाइल नहीं आता था. जब तक नोकिया यूज किया सिर्फ कम्युनिकेशन और मैसेज का सिस्टम था और कुछ भी नहीं था. In 2007 or 8, somebody brought smart mobiles. So if you see, compare the Nokia mobile with the smart mobile is a technical advance against the existing knowledge. That's the meaning of technical advance. Economic significance, there could be even a cost factor involved in it. Like आपने कोई ऐसा एक प्रोसेस निकाला है जिससे आप पैसा बचा सकते हो. So that again is also an eligible invention. And it is not obvious. It should not be obvious in a person's skill in art. Means must not obvious to a person's skill in art. A person's skill in art is an expert of a subject matter. And that person is an expert of a subject matter not in terms of his qualification, but in terms of his experience with that subject matter. So अगर IT का कोई invention है, so it is not necessary that he has to be a software engineer. He should be an expert in that. Bill Gates is not a software engineer, but he brought so many inventions pertaining to that. So he becomes a person skilled in art. He knows what is technology. He knows what is computer technology, what are the systems of computer technology. So he should not be necessarily a qualified person in terms of the knowledge. He should be a person skilled in art. When he says this is something new, it qualifies for a non-obvious patent or the inventive step of the patent. Yeah. The next which I am going is subject matter of copyright. The copyright is original literary work, dramatic work, musical work, cinematography, film, sound recording, and work of art. This is what we saw that. So copyright क्या protect करता है? What are the requirements for copyright? The copyright has to have the originality and fixation. Mere idea is not protectable as any kind of IPR. You have to have an idea which has to be an original, not copied of somebody. And it has to be manifested in some form or other. Like, I would say, ये मेरी कहानी है. अरे मेरे दिमाग में कहां से आया? तुम्हारे दिमाग को कोई पढ़ नहीं सकता है ना. तो तुमने वो लिखा कहीं, मैंने उसको स्क्रिप्ट में लिखा था या उसको किताब में लिखा था या उसको आर्टिकल में लिखा था. So that's what is this system. It has to be original idea. You have written it, created first time, and it was manifested in some form. If it is a literary work, it is in form of a book. If it is a music work, it is in a form of a composition. If it is a film, you have shot it. उसका shooting करके उसको record किया है आपने उस film को. So manifestation is the second important ingredient of copyright. It has to have originality again, and it has to have a fixation thing. Scope of copyright protection, basic of related rights and period of protection. What is scope of copyright protection? I would just ask one question, if you can answer it, if it is possible. Can a dictionary be protected as copyright? Can a dictionary be protected as copyright? So many people answered me, no, उसमें क्या है? वो तो सबको मालूम है, words and meaning के सिवा कुछ भी नहीं है. It cannot be protected, but it was protected as copyright for the simple reason, जिसने dictionary बनाई, उसने कंपाइलेशन किया, ए बी सी, ए जेड तक एक कॉलम हो गया, बी बी ए बी सी बी डी अगेन जेड तक किया.
It was
So
treated as it was treated as invention, I think.
yes, no, it was treated as copyrightable material
Okay.
because there was a compilation done. He had done a skill, he had done a labor, and he has used his own judgment. Also, not only thing, he was saying words and meaning, और वो words and meaning में वो लिखता था कि ये noun है, objective है, pronoun है, grammatically उसको explain किया था हर एक चीज को, और नीचे उसका synonyms भी देता था, जिसको हम thesaurus बोलते हैं. So if you see the totality, it was all known to everyone, but he compiled it in such a way that it could be useful to somebody. So anything which has skill, labor, and judgment can be copyrighted. A person came to me and he said that I have a different kind of formula to calculate NAV. इसको कैसे प्रोटेक्ट करने का? बोला ये एनएवी तो कोई भी मैथमेटिकल फॉर्मूला है, कोई भी कर सकता है, मैंने अलग प्रोसेस किया है, अभी उसका इन्वेंशन तो मैं कर नहीं सकता हूं, उसको ट्रेडमार्क कैसे करेंगे? अगर कोई प्रोडक्ट ही नहीं है तो ट्रेडमार्क क्या करूंगा, उसके पास सिर्फ फॉर्मूला है. आई टोल्ड हिम ये तुमने जो भी डिराइव किया है ना उसका एक प्रोसेस है, बराबर. वो प्रोसेस को चैप्टर वाइज डिवाइड करेंगे तो बोलते कम से कम 5 चैप्टर हो गए. बोलो उसको डिवाइड करो, एक मैनुअल बनाओ, और वो मैनुअल को हमने कॉपीराइट करके प्रोटेक्ट किया. Forget that. You see the game कौन बनेगा करोड़पति, it is protected as IPR. How to play that game, that fastest finger pass, ये सब सिस्टम है, एक प्रोसेस है. इन्होंने एक मैनुअल बनाया, ऑपरेटिंग मैनुअल फॉर दैट गेम बनाया, एंड दैट इज प्रोटेक्टेड एज कॉपीराइट इन यूएस. इसलिए कोई उसको कॉपी नहीं कर पाया, उसका स्क्रिप्ट बना के रख दिया वो गेम का, एंड उसको प्रोटेक्ट करके ले लिया. So that's how copyright works, and that anything which has a skill, labor, and judgment, it can be protected as copyright. These are some examples of copyright. Books, famous copyrights. Yeah. Even a photograph can be copyrighted. Composition, music. Yeah. Music companies, the systems of music companies. Napster का केस तो बहुत फेमस है. एक बार डाउनलोड कर दिया, वो फ्री डाउनलोड था तो ठीक है, अगर फ्री डाउनलोड नहीं था तुमने पायरेसी करके किया, अगेन कॉपीराइट इंफ्रिंजमेंट आ गया. मूवीज, या geographical indication, as we said that it is something which has associated with the place of origin, making its characteristics and quantity depending on feature of such source. It's a geographical origin. Geographical indications are used to inform consumer about the geographical origin of such product. जैसे दार्जिलिंग टी, और भी बहुत सारे एग्जांपल्स है. ये देखिए, these are some different kind of geographical indication product. कोल्हापुरी चप्पल, again there's a GI tag for it. Feni, Goa Feni, again it's a geographical indication. Then Jamdani shawl, Bangladeshi. Yeah. Darjeeling tea, Jamaican coffee, blended whiskey, Scotch whiskey. There's a difference between blended whiskey and Scotch whiskey. These are all geographical. I'll tell you, the Mexican economy prospered because of geographical indication. अगर मैं आपको ये बोलूं तो आप क्या सोचोगे इसके बारे में? Yeah, everybody has heard about tequila as a drink. Yes. Tequila किससे बना है? Tequila is made of an agave leaf. There's a leaf called agave leaf. पत्ता है, उसको agave leaf बोलते हैं. उसको कल्टीवेट करने का एक स्पेसिफिक प्रोसेस है जो मैक्सिकन गवर्नमेंट और मैक्सिकन फार्मर्स ने क्रिएट किया, एंड उसको प्रोटेक्ट किया द ज्योग्राफिकल इंडिकेशन. दैट मींस यू कैन नॉट कल्टीवेट agave leaf in India without the permission of the Mexican government. And see tequila today. Tequila is a very, very famous drink. It's a very famous drink. Yeah, उसके बिना पार्टीज नहीं होती है. And they are protected all over the world. Jamaican coffee. Jamaican coffee का तो बहुत बड़ा केस स्टडी है. if you want to know the commercialization of IPR, मैंने commercialization of IPR जब study किया तो Jamaican coffee का बहुत बड़ा केस था. It was the farmers who are holding this Jamaican coffee as a GI, and they created that Jamaican coffee for as a brand also. And today 400 billion cups every day is consumed all over the world. And see the kind of wealth it must have created for the Jamaican farmers. So this is the wonder of geographical indication. Next is design. Yeah, it is concerned with the visual aspect of the articles. It says that any configuration, pattern, angle, dimension, जो भी आप बोलो, it has to be applied to the product. अगर product को apply नहीं होता है तो आप design नहीं ले सकते. अगर आपको apply करना है, it has to be applied to the product. What is product? Product which can be dealt with movable. Immovable property does not come in product. So they have actually excluded something which is movable, like garden designing. That does not get covered in Design Act. Architectural drawings, they don't get covered in that. Designs of a book jacket, not. Labels, tokens, medals, building and structures have been excluded from design. He said it has to be applied to the product and that product has to be commercially dealt with. These are these few examples of design. Iron, shoe, bottles, Coca-Cola bottle. ये डिजाइन के लिए सैमसंग एंड एप्पल फॉट इन अमेरिकन कोर्ट्स एंड सैमसंग वाज मेड टू पे मोर देन $250 million as compensation to Apple for copying their design. Yes, so that's what on the legal part of what I have completed. Let's understand the commercial part of IPR, because that is something which is important for company secretaries. That's where the role of a company secretary will come in picture. Yeah, IP as a culture, business model innovations, reimagination of customer experience, and tapping new revenue streams. In 2023, TCS was awarded as Best Innovative and IP Company, Best Innovative and IP Holder Company by the Indian government. Piyush Goyal ने award दिया था दिल्ली में. So his senior management person was asked, "Sir, how did you become such a good IP and innovative company?" He said, "It has not happened in one day. We started this as a process 15, 20 years back. We created IP as a culture. We told to our people who are working in various departments, whether it's from R&D, whether it's from marketing, that we need to see that what our products are, it is actually consisting of the complete good customer experience. We need to understand something as customer experience. हमारे customer को आज क्या चाहिए और कल क्या लगेगा, वो आज ही हमें उसको सोचना है, और जो उनको कल लगने वाला है उसके बारे में इनोवेशन आज ही हम करेंगे तो कल हम पहुंच पाएंगे वहां. And before anybody else reaches, we will position ourselves for that particular innovation or product. That's how IP is created as a culture. Hindustan Lever, Procter and Gamble, jitni multinational companies hai, they have IP as a culture. And that's where the company secretary has to play an important role. There is something called board culture. वो board culture में IP को भी engrave करना है आपको. That's the role of a company secretary. That is why I said that IP is as a culture. Yeah. The economic perspective. Yeah. Xerox, Polaroid, Kodak, Gillette, ये सारी companies absolutely, they are big because of their brands, because of their technology, because of their IPR. IP protection as a policy. At micro level, it helps conversion of knowledge and information into income. Business strategy. IP should be factored by organization in their business strategy. Gillette का example देता हूं मैं. What did Gillette did when they brought twin blade technology? Before they brought twin blade technology, we used to do shaving through only manual blades. वो एक रेजर होता था, उसको खोलते थे, उसको अंदर एक कॉलम दिया जाता था, हम ब्लेड डालते थे, ब्लेड यूज करते थे और फेंक देते थे. He brought this twin blade technology. रोज रोज खोलने का झंझट नहीं, सिर्फ लगा दो, शेव करो, या ऐसे भी है कि शेव करके फेंक दो, लगाने की भी जरूरत नहीं है. So when he had this twin blade technology as innovation, he had 6 different designs in front of him. उसे नहीं मालूम था कौन सा डिजाइन सक्सेसफुल होगा. I don't know. So he said protect all the 6 design in form of whatever IP we can. डिजाइन ले लो, पेटेंट ले लो, शेप ऑफ द गुड ले लो, जो लेना है ले लो, ब्रांडिंग ले लो, प्रोटेक्टेड फ्रॉम ऑल द 4 वॉल्स. हर जगह से उसको प्रोटेक्ट कीजिए, हर जगह से उसको प्रोटेक्ट किया गया. And then he used the strategy. When he started with the basic model, it was absolutely having good response. So he understood what he has to do. Before the sale of one basic design went down, he launched the second product. Before the sale of second design went down, he launched the third product. Before the sale of third design went down, he launched the fourth product. That is why we are having Mac, Mac 1, Mac 2, Mac 3. ये brands है. And they were applied to that brand, that product. See kind of IP strategy he used. He used IP. And today what has happened with his strategy and IP? What he has done, what he has invested in IP, and what he has done IP as a strategy is that nobody could come back in the twin blade technology. There is nobody in twin blade technology other than Gillette. और जो है वो successful नहीं है. So he created a big wall of barrier that nobody can come around his IPR. And that's what is the culture. That's what he did with this innovation. Intellectual property in today's world, the market value, 80% of the market value of Microsoft is derived from intangible assets, especially its intellectual property. Value of the trademark. Coca-Cola's trademark was valued for only US business. ये बहुत पुराना फिगर है, ये 2018 का फिगर है, for $50 billion. Today the same has gone up to $150 billion. Only US business. दुनिया भर का नहीं है, यूरोप नहीं है, एशिया नहीं है, सिंगापुर नहीं है, मलेशिया नहीं है, न्यूजीलैंड नहीं है, ऑस्ट्रेलिया नहीं है, बहुत कुछ नहीं है, सिर्फ यूरोप का बिजनेस, अरे सिर्फ यूएस का बिजनेस, and $100 billion. And you know what is attributable to this $100 billion? Only 2 things. One, the brand and the shape of the bottle. ये 2 चीज मिलके ही, कोको कोला खुद कुछ मैन्युफैक्चर नहीं करता है, वो बॉटलिंग प्लांट है उसके पास, बॉटलर्स है उसके पास, उनको ये करता है क्या करवाना है, ये कंट्रोल करता है बस वो. And had more than $150 billion value of his business, and that was only that brand and the shape of the bottle. IBM earns more than $1 billion a year from patent licensing. Let's understand the importance of IB and cyber world. Protection of semiconductor chips. Domain name. It is said that Supreme Court has laid down a principle that domain name has a characters of trademark. So it can be protected as trademark. Database and data protection. We are going to regulate this IP in a different manner. We are going to have a separate regulation. TRIPS also says that suppose if you are having an intellectual property which is not forming its place in the definitions and the explanations of TRIPS, you can have your own sui generis system to protect your IP. Have sui generis system to protect your IP. That's where the data and data protection law comes into the picture. Information technology and IP. Our information technology is little bit weak. It does not have a definition of IP. But it is all about IP, how you interpret and actually make use of the Information Technology Act. Skill and knowledge have become the only source of sustainable competitive advantage. This is what the American Federal Reserve's chief, Mr. Greenspan, says that skill and knowledge have become the only source of sustainable competitive advantage. Does your management structure have a space and scope to reflect the strategic importance of intellectual property? हमारे बोर्ड में, हमारे बोर्ड के एजेंडा में कभी आईपी डिस्कस किया जाता है क्या? That is something which the company secretary has to look upon. We have in board agenda fixed related party transaction का compliance लेते हैं, PIT का compliance लेते हैं, secretarial audit का compliance लेते हैं on quarterly basis. But कभी भी एक बार के साल के board meeting में strategic importance of intellectual property कभी discuss नहीं किया जाता है. That is what is a new phase of innovation. These are some Fortune 500 companies which were valued in 1980. Out of this, whichever companies were existing in 2000, they were again valued. So when they were valued in 1980, the physical asset was 80% and intangible asset was only 20%. In 2000, the complete changeover came where physical asset was only 20% and intangible was 80%. As a company secretary, sorry. Yeah.
Have you ever wondered why hyper successful companies like Nokia, successful companies like Nokia or Kodak suddenly lose their edge? Firms like Commodore how could firms like Commodore?
Can I go back to the इसमें से कैसे बाहर निकल सकते हैं? थोड़ा सा ये कोई वीडियो प्ले हो जा रही है. I'll go to the next.
To exit it. Yes.
Yeah. Now I can come back. There's a video attached to that thing where they say that how you can do innovation without even having R&D. That's the IPR all about. Yeah. So the structure and creation of innovation culture के लिए create, protect and leverage. These are the three ingredients which are very important for the purpose of IPR. It's a structured process for creating an innovation culture. If you have to have IP commercialization, you need to learn something which is called IP audit. And let me tell you, this audit is not like statutory audit, tax audit or secretarial audit. जहां पे हमारे पास एक चेकलिस्ट है, हम उस चेकलिस्ट के हिसाब से कंप्लाई किया है कि नहीं और नहीं किया है तो हमारे पास क्या रास्ते हैं. So there is a destined process which is laid down by Institute of Chartered Account and Institute of Company Secretaries. Accounting standards है, secretarial standards है, follow किया है, नहीं किया है, यही है. So it's a kind of due diligence which we do in audit. But IP audit is not due diligence. IP audit is a systematic review of IP owned, used or acquired by the business so as to assess and manage risk, remedy problems and implement best practice in IP asset management. IP audit involves undertaking a comprehensive review of companies' IP assets related agreements, relevant policies and compliance procedure. Like I'll tell you very frankly, there's a brand called Gold Gym. Gold Gym does not have any of its own outlet in India. वो खुद कुछ नहीं है यहाँ पे इसके पास. He has just licensed his brand. He has just licensed his brand in India and he has given specifications that if you want to have this brand for your fitness center, the fitness center will have this kind of parameters. If you satisfy that, then only you will get the licensing right of it. So whether that is followed or not, whether that brand is owning what is actually being given to the licensee, whether that licensee is able to leverage that for the purpose of business, and what licensee is earning is given to the master and principal or not. If you have to see this together, this is nothing like checklist and all that. It is absolutely and complete different kind of audit. Like there are so many people from pharma companies here, as told in the beginning. Pharma companies have got a portfolio of say 300 trademarks, and their products in the market may be not more than 70 or 80 or say 100. हमारे पास 300 ब्रांड है, लेकिन हमारे पास प्रोडक्ट सिर्फ 100 है, तो बाकी के 200 ट्रेडमार्क का आप क्या करते हो? Are they earning business for you? Are they helping in growth? Are they helping in revenue earning? We don't know. Nobody is knowing about it, and nobody is actually questioning, and nobody is able to answer it, because board also does not know what is to be done. That is where the IP audit comes in picture. It involves undertaking a comprehensive review of companies' assets. IP as an asset management. You have to do it as an asset management. A systematic management of different assets that protects one or more product lines or business aspects. Suppose मेरे पास multiple classification में registration of trademark है, and I'm not using it. Why don't I license and earn out of it? But we don't think about it. IP management has 3-4 constituents. IP as an integral part of business plan. What Gillette exactly did, it factored IP in their business plan itself. It factored in business model itself. मुझे क्या करना है IP को लेके. That is why it is successful, and he could not bring anybody, even competitor भी उसके पास नहीं जा सका. IP as a policy. If you have to have IP as a culture, you have to have IP as a policy. If we have HR policy, if we have data piracy policy, if we have cyber policy, why cannot we have IP as a policy? It's a very important thing. IP audit, that's what I said. And the next is IP valuation. US business of Coca-Cola could get them $150 billion value for only 2 things: the name and the shape of the bottle. You have a kitty of 100 trademarks which are lying idle. If you value them in terms of product, वो क्या करेंगे, क्या देंगे आपको? Types of audit. IP audit is basically done for 2 purposes, 3 purposes. That general purpose of IP as a review, event-driven IP audit. When I am selling my brand or when I am selling my technology to somebody else, that's where the IP audit ends. Transaction focus IP audit. I will not name the name of my client, but they brought 3 to 4 important brands of FMCG from some other foreign company, which were having pan-India presence in India, and they were very well doing. That company wanted to exit the Indian business. So they sold it to these people, and these 3 brands to 3 to 4 brands, and they paid almost more than 3,000 crores for this only 4 brands. So that's where IP audit comes in picture. Whether absolutely these 4 brands which are sold to the Indian entrepreneur, they could generate this type of income for that. That's what the IP audit is all about. It is the landscaping of the intangible asset. It is not only tick marking or compliance. It is not the due diligence. It's totally a different subject matter where I am doing the landscaping, whether my asset is worth owning or selling or exploring it in different manner. That's where the growth strategy comes for an organization. Use IP assets, build business relationships and opportunities. It will help to achieve more than if you didn't have the IP. It turns its health and business profitability. I'll give you one case study about this. There was one person who brought accounting system in 95. When first time computers came in somewhere in the early 90s and beginning of 90s, some person devised a system of accounting which is called Tally. Correct? And everybody was copying that. So he was asked, Baba, sab tumhara copy kar rahe hai. Bola, karne do, mujhe koi problem nahi. Somebody is using it now. It's okay. He was happy. He allowed people to copy those pirated version of that accounting software. In 2005, he devised a system, or he invented a technology where there were software locks. So he put that software locks into the software. Now people cannot use that. So what he did, he created the requirement, he created the need, he created the customer base by allowing people to copy it. And now he says that now if you are used to it and if you want, mere ko paisa do pehle. So you use your IP assets, build business relationship and opportunities. It will help achieve more than what you didn't have. And it turns into business profitability. Today, Tally is having two types of business model. One is selling that software for accounting, and one is training for that software, how to use that software. So that's what the leverage of IP assets, and that's how it improves the business profitability. And this is the most amazing and important and most fascinating slide. I love this slide. What is Amazon manufacturing in this country? Amazon क्या manufacture करता है? कुछ भी नहीं. Zomato and Swiggy, how many restaurants they are owning themselves? Zero. They don't have any of their own restaurants. कभी देखा है Zomato restaurant, Swiggy restaurant, Swiggy का restaurant है? No. Oyo, is he owning any 5-star property? No. वो कुछ भी नहीं करता है 5-star प्रॉपर्टी में. उसके बाद एक भी 5-star प्रॉपर्टी नहीं है. But if you see, these are brands in the respective business. In the respective business, they are the most important thing. Can manufacturer in India survive without Amazon today? It's the biggest marketplace for all the manufacturers in this country. Zomato and Swiggy, had they not been there, the restaurant business and the hotel business in COVID time would have been destroyed like anything. It is Zomato and Swiggy which survived the hotel and restaurant business in COVID times. Oyo, he gave an opportunity for even a common man to experience the 5-star hospitality. See the business practices, see the brands, see the activity. एक भी मैन्युफैक्चरिंग फैसिलिटी नहीं है, एक भी होटल नहीं है, एक भी 5-star नहीं है, लेकिन we are the most important brand for that industry. This is the commercial aspect of the intellectual property. That's how IP can create wonder for you. That is what we have to learn about IP. IBM has more than 15. I have already told. Microsoft had 5 patents in 1990. They have more than 3,000 patents today. Intel is the highest patentee in the world, but we have only pharma people attending the IPR seminar. Yeah, had a wall of 22 patents in the product, Gillette, and see the way he created the wonders in the Gillette twin blade technology. This is the most important slide. Yes, yes, slide बहुत पुराना है, लेकिन I wanted to understand what that inventor, he was an individual inventor. The inventor licensed the system to Coca-Cola and earned 1/10 of penny per can. During the period of validity of patent, the inventor obtained 1,48,000 UK pounds a day on royalties. See the amount of royalty he has earned during the existence of this patent. एक इंडिविजुअल. हमारे पास तो कंपनीज है, हमारे पास तो बोर्ड है, हमारे पास इन्वेंशन के लिए सारा कुछ है. What wonders we can create if we guide the board in the right direction. This is the most important model which is developed in Western countries. We need to do the same thing in India also. Have you heard about Stanford University? Everybody has heard about Stanford University, correct? So Stanford University में 2 बच्चे पढ़ते थे for computer engineering. वो दोनों बच्चों ने as a curriculum they had on last semester where they were supposed to do some inventive work, some research work and create a prototype. So they created a prototype and submitted to Stanford University as a student. Stanford University qualified them as a computer engineers. They came out of that university, fell in love with each other and married. So they wanted to do something more than their employment as a livelihood. So they said, let's start some new business. So business के लिए product चाहिए, हमारे पास product नहीं है. So wife was very intelligent. He said, we have product. The prototype which we submitted to industry, I think can work as a good product. Because that was a prototype which university also appreciated and said that this is one of the best research work we have seen. So they launched that prototype, they converted that invention into a product, and that's how that product became very successful in IT industry, and that's where the router was born. In the late 80s and early 90s, that's where the router was born. And that company which created this innovation is Cisco. So Stanford University came to know about it. She said the innovation does not belong to the students. It is owned by university. They were the students and we have given them degree because of this. So they don't own this. So Stanford University was in a process to sue them. So this student said nothing doing. We don't want fight. What we are because of our education and our university. So we will respect you. And they gave them $150 million as royalty for that product. And not only that, they signed an MOU with Stanford University that henceforth, whatever research we are going to do, it's with the collaboration of university. That is why Stanford University become rich. So university also become prospered because of IPR. So we have so many universities here. In 2023, one of the Punjab University was awarded as the best university for filing highest patent. I don't know whether this university has a commercial angle to it or they have a commercial plan that we can commercialize these patents. That's what is the role of a company secretary everywhere. Commercialization of IPR. Yeah. There are some beautiful case studies as far as IP commercialization is concerned. The first case is Pliva versus Pfizer as a synergy story. Pliva was an R&D company in East Europe and absolutely not doing very well. Let's see what Pfizer was thinking about it. And how did Pfizer came across Pliva? Pfizer, a well-organized pharma company, they were planning to launch a very, very important formulation for antibiotic. So it's a very well-managed board, well established and process and systems, well practiced. Everything is well practiced. So what did they do? What they did do is that they planned everything. The R&D gave them the research structure, they gave the cost factor, they gave them how they will convert this research into product, when will the product launch, when the product will earn break even, and when will Pfizer start having profit out of this product. Everything was planned and it went for execution. So the finance department of Pfizer said that whether this technology will work and to what extent it will work. Now, board had decided everything, but still, finance was thinking, let's evaluate it in a different manner. कि हम पैसा कैसे कमाएंगे इस पैसे. So that let's see what type of technology, like what our R&D is planning, कि दुनिया में कहाँ है ये technology. So they came down upon across the patent which was filed by Pliva for the same type of antibiotic. It was similar but not identical. Somewhere near to what Pfizer was trying to develop in terms of antibiotic. So Pliva ने बोला, अच्छा ठीक है, let's see what is Pliva doing and what is their earning out of this product and this technology. And they were surprised. Pliva had filed for bankruptcy. They had filed for insolvency. That was going to close down. So Pfizer finance people got surprised. Why such a company, such a good company, and they had a technology, but they are absolutely going for winding up. So they approached them and they said, what went wrong? He said, no, your technology is beautiful, patent is very good, but operationally and managing finance, we failed somewhere, and that is why we are filing in insolvency. The technology had no problem, product had no problem, but we could not manage the finance properly, and that is why we are going for insolvency. So the finance people of that Pfizer asked Pleva management, what are we going to do with this patent? The management said, I don't know. What are we going to do this? We don't know what are we going to do this patent. The patent has nothing to do with this insolvency. We don't know what are we going to do this patent. So Pfizer formulated a synergy and a strategy. He said, why don't you work together with us? We will take you out of this bankruptcy. You need not file for bankruptcy. You need not go ahead with the bankruptcy. We will help you out. You be with us for this technology. And there was an idea generated out of this. The finance team of Pfizer went to the management. He said, look, here we have an opportunity when instead of 3 years or 2 years or say more period where we could get the break even, we will start earning immediately. It's only thing that we need to help this company to come out of insolvency, and they will be our technology partner. So the way both of them entered into a synergy, and they entered into a mutual benefit sharing agreement where Pleva decided to license the technology to Pfizer, and Pfizer decided to give them money to survive. And they survived. Pfizer launched that antibiotic. That antibiotic is today also very, very successful. It has an income of $1 billion a year, single product, one product, $1 billion a year in US. But what happened to Pfizer is not important. What happened to Pleva is very important. Pleva was on the doorstep of winding up. They were going to close down. What happened was Pleva survived, and not only survived, today Pleva is a very successful R&D company in East Europe, doing research for all the multinationals all over the world in pharma sector. That's the wonder of the IPR commercialization. Dolby. Yeah. Dolby is a sound technology company. The owner of Dolby was a sound engineer, and as a sound engineer, he was very fond of sound. He used to keep on doing some kind of experiments of sound. So one day he invented something called as digital sound technology. We had analog sound technology. Sound system में stereo था, लेकिन digital stereo नहीं था. He brought digital stereo in this world. He filed for patent, and he knew that once my patent is out, people will try to replicate my technology. So he said, don't do that. वो इतना मेहनत मत करो, मैं आपको लाइसेंस दे देता हूं. I am not going to exploit this technology worldwide. I am going to only exploit this technology in US. जिसको भी चाहिए लाइसेंस लेके जाओ. But then he put one condition that I will not only license my technology, I will also license along with technology my brand. आपको सिर्फ पेटेंट का लाइसेंस नहीं मिलेगा, मुझे मेरा ट्रेडमार्क का लाइसेंस भी लेना पड़ेगा. अगर आप ये दोनों लेते हो तो मेरे पास से ले जाओ. So what did he do as a strategy is he branded his technology, he married his technology with the brand, and together he said this is the package. His 2/3 income comes from the licensing revenue. And believe me, there isn't parallel digital sound technology in the world. There is no parallel brand to Dolby. DTS, आप देखेंगे हर एक फिल्म के नीचे एंड में आता है DTS. That's the brand of Dolby.
Sir, we can take some questions also if you permit me.
Sir, I don't mind. आपने इंटरेक्शन बंद कर दिया because of technology, नहीं तो मेरे को तो वही चाहिए सर.
So I am getting many questions, sir. So with your permission, may I take?
Yes. So I'll do one thing, sir. I'll take one more case study. Last,
Please.
हम थोड़ा question लेंगे and then I'll again come back on the role of company secretary and then we can conclude the session.
Correct,
Chalega?
sir. Yes, yes, it will work.
Yeah.
Sir.
So that's how the Dolby's strategy works. Let me take the last case study is Kodak disaster story. This is very famous. Why I want to study, make you know about this strategy is because it's an issue related to corporate governance. Even IP has something called governance issue. Let's understand what that governance issue is all about. It so happened that there were 4 engineers working in Kodak and they had planned for a camera technology. So they went to the Kodak management and they said, we want to have this plan, we can have this research done and we can launch a new product. Kodak rejected it, said, we don't want to work on this technology. These 4 engineers were sad. So they came out of the Kodak and started their own company, did the R&D and launched that product. पुराने जमाने में हमको फोटोग्राफ कैसे मिलते थे? अगर आज हमने फोटो खींचा है तो दूसरे दिन मिलता था प्रोसेस होके. Yes, there was a system and process. These people had something called instant camera technology. कि आप फोटो खींचिए, within 20 minutes and 40 minutes, you'll get the process photo. So they developed instant camera technology. It got wonderful success, but Kodak ने बोला ये तो हमारे इंजीनियर से, ये हमारा क्या बिगाड़ के लेंगे, करेक्ट? तो उन्होंने वे परवाह नहीं की and they started selling the same camera technology. They also copied that technology and started with the Kodak's brand. Now these guys were new. He said, if Kodak starts selling, we are out, we'll finish. So they said, we will not be able to fight with Kodak. So one of them say, वैसे भी हमको बंद होने वाला है, हम कुछ नहीं कर पाएंगे, so let's fight with them. Let's see, let's try and fight with them. Why should we give up like that? Let's fight the battle. So they sued Kodak in 14 countries. सब कुछ दाव पे लग गया, सेविंग्स दाव पे लग गया, सब कुछ दाव पे लग गया उन लोगों का, but they absolutely डटे रहे. The dispute went around for more than 1.5 years. But at the end of 1.5 years, those 4 engineers won the battle. They won the suit for patent infringement and Kodak was made to pay them more than $200 million as damages for copying and infringing their patent. Now that is not enough for Kodak. The courts in different countries say that you have not respected somebody's IP. So what you are supposed to do now, you call back all the cameras which are sold with their technology and you buy back them. And whatever amount you get it, you have to reimburse to these people because it was their technology. And that is where Kodak had a big disaster. It had to come out of that instant technology. Camera technology se bahar aa gaya Kodak. That's the Kodak trade decision. So the outcome and the point which I want to make with is that respect everybody's IP. Respect somebody's IP. That's the biggest corporate governance. That's the biggest corporate governance in terms of IP. Make your board understand that IP, somebody's IP has to be respected. You cannot just copy like that. It will be a problem. Yeah. Now we can take question answer.
Yes, sir. So
With
the
your kind
first
permission, can I have a cup of coffee for me in my office?
sure, sir. Sure, sir.
Thank you. Tell me, sir.
So, first question is very interesting. How can a fashion designer protect his apparel design?
Yes, that is called trade dress. It is protected as trade dress.
Okay, sir.
There
And
is something called trade dress. It can be part of copyright, it can be part of trademark, or it can be part of both. You have to formulate a strategy to protect that and still you can do it. Japanese fashion designers are the most famous in protecting this as an IP and leveraging this for the business.
okay, sir. And what is the basically legal requirement for this?
Either you have, like I told you, the shape of the goods are also protected as trademark.
Correct, sir.
Like to take the trademark and the artistic feel of that design, of that trade or the fashion design, whatever he has created a product or he wants to create. Artistic part, you can protect it as copyright. So here you have trademark and copyright both.
Okay, sir. Okay. And sir, second question is very relevant for the company secretaries.
Yes, please,
What
sir.
is the process to become a patent attorney? Or
Yeah,
how can a PCS how can a practicing company secretary can become a patent attorney?
yes, this is very important. I am actually a registered trademark agent as company secretary, not as a lawyer. Lawyer में बाद में बना हूँ. I started doing practice as a trademark agent in 2001, and I have registered myself as a trademark agent as a company secretary, not as a lawyer. So this
Correct.
is the process which is to be followed. And अभी तो वो ऑनलाइन हो गया है, लेकिन थोड़ा वो साइट का प्रॉब्लम है, थोड़ा वो सिस्टम का प्रॉब्लम है, and there were some problems created by some company secretaries in the Bombay trademark office where the controller decided not to grant trademark agent status to company secretaries, but our president and our institute absolutely intervened, and
Yes. Now they are giving us, sir.
yes, now they are giving it, but थोड़ा process slow है because वो site they have changed their software systems. तो
Correct.
थोड़ा site का problem है, थोड़ा slow चल रहा है, but they are giving it. So bear with the site. See, government की site slow चलती है, हम कुछ नहीं कर सकते.
No, sir. No, this question is with respect to patent, basically.
Patent, if you are a science graduate, you can pass the patent agent exam and become patent attorney.
So if you are a practicing company secretary and to become
a science graduate, if a practicing company secretary is a
become a
science
patent attorney, you need to be a science graduate and then you have to
yeah,
appear for the
the
examination.
Patent Act in 2005 says that science graduate can only become a patent lawyer. Now, there also we had recommended to the industry, to the government, like in US there is a system. You need not be a science, but suppose आप एक subject matter, एक technology के बारे में आपको patent का knowledge है या आपको है, you take training in that sector, like electronic है या biotechnology है या pharma में, there are people who there are institute will give you some hours of training, like 50 hours, like pilot को कैसे 100 hours का flying training complete करना.
Correct, sir.
The same type of training is given for the technocrats. Non-technocrats को technocrat की training दी जाती है, and then he qualifies to become a patent agent. Now, unfortunately, India में the government is not able to take steps, but Madras High Court में एक direction आया है कि you should do this करके.
Yes, we are very hopeful in that in future.
Yeah, it will. It has to happen. It's only it has to happen that it's not. It has to get a good representation.
Correct, sir.
Those company secretaries who are science graduate can still do that. I have done that with some of my colleagues.
Yes, sir.
Yeah.
So, sir, we have 15 more minutes. I would like to request you. Meanwhile, you can take the role of company secretary, and after you complete that portion, we'll take for 5-10 minutes. We'll take some more questions.
Sure. No, I will complete in 5 minutes. Then we can take more questions.
Yes, sir.
That will be more. I want this to be interactive, but unfortunately, the system didn't allow me. That's okay.
Sir, the session is going very good, and we are getting very good feedback. So,
no problem.
10 minutes will take questions, sir.
Yeah.
You kindly cover the part of role of company secretary.
Yes. So, what is the role of a company secretary? Let me tell you what is the role of the company secretary. There are two basic rules of a company secretary. Number one is that those who are in employment, they have to understand that today all different kinds of IP is lying in the back room of legal. Legal वाले handle करते हैं, हम company secretary भी legal में है. We are also legal head somewhere. But the IP lies in the back room of legal. You have to bring that IP strategically into the boardroom. Explain the importance, strategic importance of each and every IP and how it can absolutely help in growth strategy of an organization. This is the first role of a company secretary. Second is IP commercialization. Be a part of IP commercialization. Until and unless people from long non-legal background and people who are commercially, we are very much commercially equipped people to understand what is the commercial importance for a growth and strategy for a board and a management. So become a part of IP commercialization. If you are a part of IP commercialization, if you know IP audit, like formulating an IP policy and formulating an IP audit cannot be done by lawyers. They will not do this. This is something which we have to bring to the board and management, that IP audit and IP policy, lay down IP policy. Until and unless board commits to the whole world and to the organization that we are committed to IP, nothing will happen. Like I told you, TCS committed, TCS management committed that IP has to be a culture. And that is why that company got awarded as the best innovative company and as an IP company. So that's the role of a company secretary. Help management to create IP as a culture. Ask for go for IP audit. Go for IP as a policy. Draft an IP policy. Implement an IP policy. Help management to implement an IP policy. This is the real role of a company secretary. Yeah. So this is my last slide. In today's economic world, strong IP system can help economics on the path of growth and prosperity. As Joseph Consus says that profit is a return on successful innovation. So now we can take question and answers.
Yes, sir. Thank you
And
for.
I'll come back to whatever the knowledge part of IPR is on that question and answer. That would be more.
Yes. So, without I'm taking questions, sir. Sir, can we? The question is, can we claim international protection of trademark?
Yeah.
Within TRIPS, without
Yes.
obtaining respective registration?
I'll tell you how international trademark. That's
Yes,
where I wanted to make a point that IPR rights are traditional and territorial.
Okay.
Every IPR rights are territorial. If I am having a trademark in India, that does not mean I own this trademark all over the world.
Yes.
Wherever I am having a strategic and business importance, I need to go and protect that brand in that country. And if you are a registered trademark in India, you can claim the priority of your Indian registration, or even if you have applied in India, if you have a priority date of that trademark application in comparison to others, you can go to the respective countries. Like suppose if I want to protect, say, my brand, I have a brand called Platinova. Now, Platinova, I have applied for brand in India. I am going to go to US and to the European domain to file trademark application, saying that I have filed this trademark application in 2023. It is still pending registration, but I claim the priority from 2023 and I want this to be protected in your respective geographical jurisdiction by following the law and system of that country. You can do that. You have to appoint lawyers in that respective country and they'll help you do that.
So, sir, next question is whether an agreement is required for applying the copyright or trademark.
No, you don't require any kind of agreement. See, as far as copyright is concerned, I'll come back to it after we answer. Trademark ke liye koi agreement nahi. There is an.
Yes, and one more point I want to add here, sir. If as a trademark agent you're applying something, or so you should have proper power attorney on behalf of your client. I think that is very
Yeah. That's a process and procedure laid down in the trademark law itself.
Yeah. But separate agreement is not required. Sir,
No.
Next question is very interesting, and it is related to medical industry basically.
Yeah,
Can Siddha and Ayurveda medicines be patented in India?
Yes, if you have done a process and procedure to use that particular Ayurveda sculpture, you use sculpture, but you developed your own formulation, then you can protect it as a patent. But वो knowledge है which is in public domain, like Ashtanga Ayurveda हम patent नहीं कर सकते.
Correct.
Like I tell you a very good example for Ayurveda is time Gaumutra cannot be protected as patent. But medicinal properties which I have identified, like I have identified medicinal properties of Gaumutra for the purpose of treatment of diabetes. That identification, that process of producing that medicine out of the Gaumutra is something which is my domain knowledge, and that can be protected as patent.
Correct, sir. Sir, although you have covered this question in your presentation, but like if they are asking, I'm repeating it again. What is the scope of practicing company secretary in the domain of intellectual property right, apart from trademark related work?
Yeah, there are so many things I told you, no? First of all, at strategy level, we should get involved in formulating IP as a policy for the boardroom. See, board of directors, there is no, I told you, board agenda में आपने कभी देखा है कि IP को दिया गया है?
करेक्ट।
आईपी नहीं डिस्कस किया जाता है, जबकि
Yes.
आपके पास हिडन आईपी है. देयर आर सो मेनी हिडन आईपीज व्हिच एन ऑर्गेनाइजेशन इज हैविंग. Like
Okay.
suppose that person who's asking me question about this is he from pharma industry. अगर फार्मा इंडस्ट्री में है तो उसके पास कितनी हिडन प्रॉपर्टीज है, कितने आइडल पेटेंट है, कितने आइडल ट्रेडमार्क है. उसका ग्रोथ स्ट्रैटेजी के बारे में सोचा. हम पैसा भरते हैं, हर एक ट्रेडमार्क को रिन्यूअल करना पड़ता है, वो रिन्यूअल का कॉस्ट है, पेटेंट को मेंटेन करने का कॉस्ट है. उसके सामने हमको बेनिफिट है क्या?
So you can give a cost
Absolutely.
comparative basis.
Like there are economic aspects and leveraging of IP asset can be done only by non-legal person. Legal person will not do that. Like I said, that create, protect, and leverage. These are the three constituents of innovation and IPR. So creating and leveraging is something which we can get involved.
Sir, one more question is there, which is very relevant for many, you can say,
Yeah,
professionals.
please, sir. Please.
Our company is developing a platform to bring the parties on the basically on the platform and connect with them. Whether the same can be protected as a copyright, whether the platform design or basically content or both can be protected as a copyright.
See, platform business में कैसा रहता है? If there is a tool or technology, like matching कैसे होगा? How you will match to bring a consumer and a dealer together? Like Amazon के पास सॉफ्टवेयर है, बराबर है? Amazon के पास पेटेंट भी है. You know what Amazon does it? Like suppose Amazon पे आपने जाके आपने खरीदा है, सपोज 3 महीने पहले आपने खरीदा था, एक से शेविंग किट खरीदा है 3 महीने, तो शेविंग किट 3-4 महीने के बाद यू मे रिक्वायर इट अगेन. सो आप एट द एंड ऑफ 3rd और 4th मंथ जो भी क्वांटिटी आपने खरीदी है, पेटेंट Amazon विल ब्लिंक इट टू यू दैट डू यू रिक्वायर दिस शेविंग किट. हाँ, दिस इज कॉल्ड एंटिसिपेशन ऑफ कंज्यूमर नीड. एंड उसके पास सॉफ्टवेयर है, वो सॉफ्टवेयर का उसने पेटेंट लिया है. So if you are having tools and system for doing business on that platform, those tools and system, if they are having invention, they can be protected as patent. Whereas the design and the content part of the platform can be protected as copyright.
Okay, sir, you can stop sharing your presentation because we
Yeah,
can
sorry.
better way. So, sir, one question is coming in my mind. Like in the era of artificial intelligence, everyone is using Chat GPT and Pilot and other like intellectual like AI platforms. So if as a company secretary, if you're putting something on the platform of IP, and when you see the terms and condition of their basically of those platforms, they are mentioning if you are putting any information on this platform, this will become the intellectual property of that platform only. So how a company secretary should take care while he is using those platforms? So I think this is a very relevant question here.
Yeah. See what WIPO has laid down the guidelines as far as AI is concerned. He said AI has two things. One is the machine intervention and one is a human intervention.
Correct, sir.
So what human intervention is created using AI, only AI has facilitated the human intervention, then the human intervention part is protectable as a IP. But what is created by say AI itself, it cannot be protected because that is generated by machine. But machine does not generate anything. Let me tell you very frankly, this is what my experience about AI patents are. आप AI को जो डेटा देते हो, जो फीडबैक, उसको जो कंटेंट देते हो, जो इनपुट देते हो, वो इनपुट किस हिसाब से देते हो और आप उसके पास क्या मांगते हो, वो जो पोर्शन है वो ही आएगा, ये नहीं आएगा. जो ह्यूमन इंटरवेंशन है वो आपका है, जो ह्यूमन इंटरवेंशन से क्रिएट किया. लाइक किसी ने बुक लिखा एआई को यूज करके, करेक्ट, बट बुक कैसे लिखा, उसको जो चैप्टर्स थे, उसको जो कंटेंट था, जो पैराफ्रेजिंग था, जो इंडेक्स था, वो तो ह्यूमन ने दिया ना उसको.
यस सर.
Correct. So what is the human intervention can be protected as IP? What is machine created on its own does not fall in IP.
नहीं सर, यहाँ पे मेरा क्वेश्चन सर थोड़ा सा डिफरेंट है कि
बोलिए ना.
इफ एज अ प्रोफेशनल मैं कोई इंफॉर्मेशन, फॉर एग्जांपल किसी कंपनी का लोगो मैं चैट जीपीटी में डालता हूँ उसको डिजाइन करने के लिए कि प्लीज प्रोवाइड मी अ बेटर लोगो बाय यूजिंग दिस एग्जिस्टिंग लोगो, तो क्या वो जो मैंने अपना एग्जिस्टिंग लोगो उस पे अपलोड किया चैट जीपीटी पे, वो एग्जिस्टिंग लोगो वो हो सकता है कहीं और भी यूज करे, उससे लिया हुआ आइडिया वो कहीं और भी यूज करे?
नहीं, नहीं कर सकते। अगर वो करता है तो दैट्स अ वायलेशन।
ओके, बिकॉज जब हम चैट जीपीटी का वो एग्रीमेंट देखते हैं तो उसमें
हाँ,
ये बोलता है कि अगर आप इस प्लेटफॉर्म पे कुछ भी अपलोड करते हैं तो चैट जीपीटी कैन यूज दैट पर्टिकुलर इंफॉर्मेशन फॉर फ्यूचर फ्यूचर रेफरेंस और फॉर फ्यूचर सर्च।
फाइन, नो प्रॉब्लम, बट ही कैन नॉट यूज इट फॉर कमर्शियल पर्पस।
ओके, ओके सर,
अगर कमर्शियल पर्पस आ गया तो देन देयर इज अ वायलेशन।
okay, okay. So I am moving towards the next question. Actually, we acquired one company at Mauritius. Can we incorporate that acquirer IP in our patent company letterhead without any action in India? Is it possible, sir?
See, what you, if you have acquired the company, you have acquired the IP also along with that company.
I think.
So when you acquire everything, what belongs to Mauritius company belongs to you now.
Hmm.
So how to use it is, yes, it is you. So that scheme of merger or acquisition which you have done should have a specific clause that all the intellectual property of the transferor company will now belong to transferee company. If that clause is there, it is yours.
Correct. So one question related to basically future planning, like after death of a proprietor of a intellectual property, right? Company is split in vertical between two sons, and one son is using intellectual property trademark, but other brother may raise objection in future.
Yes, he
How
can.
to protect this kind of problem in the
Yeah. So
corporate?
first of all, I have to understand that when the person has died, whether the intellectual property was in his name or in company's name.
Yes.
That is one thing. If it is
And
in, it is in,
actually, in case of proprietorship firm, the rights are
yeah.
in the name of
So
the
actually,
person.
both the sons have equal rights.
Yes, sir.
Because in intellectual property is also inheritable. I told you, everything about intellectual property is like immovable property except for physical possession.
Correct. So it will be
Both the sons have equal right. One son cannot use it at the cost of other.
yes, yes, yes. So
Except
it
there
will
is an
be
agreement that I am releasing my right, you use it. Except for this, like there is something called family trademark.
correct.
So in family trademark, Supreme Court has laid down the principle that unless and unless contrary something is writing, nobody has got exclusive right. It is everybody who has got equal rights.
Correct. So it will be simply like an
Immovable
immovable
property,
property.
yes, it will be like,
Thank
except
you.
कोई will है, will में लिख के गया है फादर का, इस मेरे ये ट्रेडमार्क ये बच्चे को मिलेगा, ये इसको नहीं मिलेगा,
तो
वो
वो सेम उसी तरह से होगा जैसे
देन
immovable.
उसी तरह से होगा, otherwise it will be equal right to everybody.
Correct, sir. Sir, next question is for protection of brand name. Can a registration as composite mark, that is device as per the TM registration option, is sufficient, or it is mandatory that brand name should also be registered under the word mark to get the protection from for brand name?
See, composite mark में कैसा रहता है कि suppose there are a composite mark में तीन चीज है, word mark है, logo है, and punch line भी है.
Okay.
Like, हमारे पास एक है कि MSA shipping, delivery excellence. तो MSA shipping is a trade name, उसका logo है and एक punch line है delivery excellence. अगर तीनों चीज है, it can be registered as composite mark, but the trademark law says that if you feel there is a constituent, each and every constituent has its own importance, then each and every constituent is required to be registered under section 17 of the Trademark Act.
यस सर, बट सर जैसे सिंपली अगर मैं बोलूं फॉर एग्जांपल HCL है, अब HCL ने अपने आप को लोगो एज लोगो रजिस्टर करा लिया ब्लू और व्हाइट कलर का जो उसका लोगो है बेसिकली, सो इज इट रिक्वायर्ड टू रजिस्टर्ड एज वर्डमार्क आल्सो?
Yes, it is.
Many company secretaries are facing this problem. Client is asking कि we need 100% protection, and they are not using any punchline. And simply, if we are registering it as a logo, so जो उनका कंसल्टेंट है वो बोलता है कि नहीं जी आप तो इसको वर्ड मार्क भी रजिस्टर कराओ, तो व्हाट इज द बेस्ट वे
No,
टू
actually,
टू टू सिक्योर 100% प्रोटेक्शन बेसिकली? from
वर्ड
any
मार्क में
organization.
कैसे होता है कि वर्ड मार्क अगर स्पेसिफिक स्टाइल से लिखा गया है और उसका कलर कॉम्बिनेशन है और आपकी एप्लीकेशन में यू आर राइटिंग दैट आई एम क्लेमिंग ऑल कलर कॉम्बिनेशन, देन यू नीड नॉट गोइंग फॉर सेपरेट वर्ड मार्क रजिस्ट्रेशन. बट अगर आपकी एप्लीकेशन में कलर कॉम्बिनेशन नहीं क्लेम किया है तो इट इज बेटर दैट यू गो फॉर अ वर्ड मार्क रजिस्ट्रेशन.
I think this is very important aspect that every professional should write this,
या
that we are
क्या होता
covering
है कि
all
हम
color
ट्रेडमार्क, हाँ,
combination.
हम ट्रेडमार्क का फॉर्म ऐसे ही भरते हैं जैसे फॉर्म 32 या फॉर्म 18 भरते थे पहले. हम
Yes, sir.
अपना दिमाग नहीं लगाते हैं कि इसमें इसका रिपरकशन क्या है, ये क्यों बोल रहा है.
Correct, sir. Correct. I think this is very important.
Yes.
कि जब भी नेक्स्ट टाइम आप ट्रेडमार्क अप्लाई करें तो ये जरूर मेंशन करें कि we are
What are we
covering
writing?
all color
Yes.
combinations.
हाँ, कलर, ऑल कलर कॉम्बिनेशंस. हाँ, फिर कोई भी कलर में करूं, कोई दूसरा कोई कलर डाल के भी करेगा तो आई कैन स्टॉप हिम.
करेक्ट सर. सर एक क्वेश्चन इसके अंदर बड़ा इंपॉर्टेंट ये आया कि वाई लिटिगेशन इन पेटेंट लॉ आर वेरी टाइम कंज्यूमिंग, व्हाट आर बेसिकली कॉन्स्ट्रेंट in patent law litigations?
See, I'll tell you, IPR litigation में कैसा है, how the legal system functions. Like, suppose there is a violation of a patent. My patent right is infringed. So what I will try to do is, I'll try to bring injunction first. अगर मुझे इंजंक्शन मिल गया तो सामने वाले को जो होना है वो है. मेरे को तो इंजंक्शन मिल गया, ही कैन नॉट यूज द टेक्नोलॉजी नाउ.
करेक्ट.
बट अगर इंजंक्शन नहीं मिला है तो मैं लॉस में हो गया. सो आई विल ट्राई टू फाइट फॉर इंजंक्शन एंड दैट फेलो विल ट्राई कि इंजंक्शन ना मिले. दैट वे टाइम चला जाता है. अगर इंजंक्शन मिल गया और सामने वाले को यूज नहीं कर रहा है तो वो सामने वाला निकल जाएगा. बट द सूट रिमेन्स. What is decided is only an interim relief. The suit remains whether there was a real infringement of the patent.
ओके सर. सर एक और देयर इज वन वेरी इंपॉर्टेंट क्वेश्चन कि व्हाट आर द बेसिकली थ्रेश होल्ड. फॉर एग्जाम्पल अगर मैं किसी कंपनी का ट्रेडमार्क इन्फ्रिंज कर रहा हूँ, सो दे आर कमिंग एंड सुइंग मी इन द हाई कोर्ट, तो इंजंक्शन हाई कोर्ट से लेते हैं, तो इज देयर एनी थ्रेश होल्ड लिमिट कि भाई किस लेवल पे आपको सेशन कोर्ट में जाना है, किस लेवल पे हाई कोर्ट में जाना है, एंड व्हेन यू आर मूविंग टू सुप्रीम कोर्ट?
These IP litigations are special kind of litigation. तो इसमें थ्रेशोल्ड नहीं रहता है. जिसको ओरिजिनल जुरिडिक्शन है उसी में जाता है. It is said that
in case of injunction you have to go to high court.
Yeah. Are not necessarily. Suppose अभी पुणे में है कोई आदमी और पुणे में ट्रेडमार्क, it's a owner of the trademark is in Pune. The infringer is also in Pune. He does not need to come in high court. He can go to the district court and file कि ये मेरा ट्रेडमार्क इन्फ्रिंज कर रहा है.
तो सर वो एक बार कैन यू प्लीज गाइड अस फॉर द बेसिकली ओरिजिनल ज्यूरिसडिक्शन कि कहाँ पे हम जा सकते हैं इन केस ऑफ इन्फ्रिंजमेंट, इफ यू कैन टेल.
It all depends what is your IP सूट का स्ट्रेटेजी क्या है. बराबर. अभी मेरा वायलेटर, सी where is the cause of action? In trademark, if you read section 134, it said that you can file an infringement suit where the plaintiff resides. I am the owner of trademark. मैं बंबई में हूं तो मैं बंबई में भी फाइल कर सकता हूं. इन्फ्रिंजर कहीं पे भी होने दो. बराबर है. लेकिन एक ट्रेडमार्क के सूट में दो तरह के सूट होते हैं. वन इज इंफ्रिंजमेंट सूट एंड वन इज द पासिंग ऑफ रेमेडीज.
यस.
पासिंग ऑफ रेमेडीज इज अ कॉमन लॉ रेमेडी. इट इज नॉट एज पर ट्रेडमार्क एक्ट. हाँ, तो पासिंग ऑफ अगर आपको चाहिए और कॉमन लॉ रेमेडी भी चाहिए तो आप डायरेक्टली बॉम्बे हाई कोर्ट नहीं जा सकते. So it all depends what type of remedy you are seeking. You are just seeking an infringement remedies. Then you go to the high court. But if you want passing off also, then you have to go to a district court where it's a jurisdiction. I mean, see, cause of action कहाँ है? There are two things. Owner of trademark कहाँ है and cause of action कहाँ है?
Sir, for the benefit of participants, if you can explain this passing of remedy and infringement remedy. Infringement तो is very simple. We know कि अगर किसी ने हमारा ट्रेडमार्क इन्फ्रिंज किया, so we can file a suit against that particular person.
It's not like that, sir.
Yes, please explain, sir, in detail.
If I am having a registered trademark,
yeah,
मेरा ट्रेडमार्क रजिस्टर्ड है, so I am absolutely a king. I am holding that possession. मेरा प्रॉपर्टी है, I am possessing that property. So then infringement comes. But अगर मेरा ट्रेडमार्क रजिस्टर्ड नहीं है,
in that case
पासिंग ऑफ करना है.
Okay.
करेक्ट. बट कैसे होता है कि in infringement suit passing off is also there. Correct. मुझे इन्फ्रिंज किया, यानी मेरे नाम से वो जाके गुडविल, मेरे गुडविल पे ही इज यूजिंग इट इन द मार्केट।
करेक्ट।
इन्फ्रिंजमेंट सूट तो मेरा रहेगा ही, बट मुझे पासिंग ऑफ की भी रेमेडीज लगेगी।
ओके।
तो उसे ये सराउंडिंग सर्कमस्टेंसेस डिसाइड करके कहां जाना है, दैट्स व्हाट द स्ट्रेटेजी। आईपी लिटिगेशन इज ऑल अबाउट स्ट्रेटेजी अगेन। आईपी इज इटसेल्फ इज ऑल अबाउट स्ट्रेटेजी. Like I'll tell you very frankly, I have a client who had a trademark, correct? Now he had office in Nagpur, but the infringer was in Mumbai.
ओके।
हाँ, तो एज अ ओनर एंड एज अ बिजनेस, वो कंपनी प्राइवेट लिमिटेड कंपनी थी, कंपनी के नाम पे था प्रॉपर्टी, वो उधर बैठा है, वो नागपुर में भी जा सकता था, लेकिन मैंने कॉज ऑफ एक्शन कहा है, बेटर टू कम टू बॉम्बे हाई कोर्ट। तो मुझे दोनों मिल जाएगी, इन्फ्रिंजमेंट भी मिल जाएंगे, पासिंग ऑफ के मेरे। अगर मैं सिर्फ नागपुर में जाता हूं तो मेरे को सिर्फ इन्फ्रिंजमेंट मिलेगी, पासिंग ऑफ की रेमेडीज नहीं मिलेगी, बिकॉज कॉज ऑफ एक्शन इज इन मुंबई।
ओके।
या
Okay, okay, sir. So, sir, thank you very much. Actually, I'm telling you, I have learned a lot, and it was very interesting session. And although we are getting so many questions, but due to paucity of time, we could not take. So, but sir, it was very knowledgeable and very interactive session, I would say. And the last part was the question answer part was very good. And institute is also forming basically task force on intellectual property, right? So at this platform, I would like to request all the members, if you are interested to join that task force, if you are working in the field of trademark, copyright or IPR, you may basically write your interest to the institute at present email ID present@ICSI, and you can mark a copy to me also, Suresh .pandey@ICSI.edu. So I will request Nayan sir also to join that task force.
100% सर, एनी टाइम आप
Definitely
बताइए
will.
क्या चाहिए आपको, आई विल हेल्प यू आउट फॉर द टास्क फोर्स।
Thank you so much, sir. And finally, sir, we are concluding this sessions on behalf of all the participants and on behalf of ICSI. I would express my gratitude of thanks to you from my bottom of heart. And thank you so much
थैंक
for
यू, इट्स
sparing
माय
your
प्लेजर, इट्स
valuable
माय
time.
प्लेजर।
And it was very interesting session, sir. Thank you so much. Thanks all the participants to join this webinar. Thank you very much, everyone. Thank you, sir. Thank you once again.